hold on to your seats. We got a great U.S. LawShield live here on YouTube and Facebook. Thank you for joining us. I'm independent program attorney Richard Hayes, joined by the brilliant Edwin Walker. How are you doing, Edwin?
I'm doing great, thank you.
Today, we're talking about high-profile cases and the lessons learned. We're going to be talking about the Kyle Rittenhouse case, the Kenosha case, the Ahmaud Arbery case involving the McMichaels, and finally, we're going to be talking about this a little less known because it happened a while ago, but it just went to trial, so we have to talk about it. The Curtis Reeves, also called the popcorn shooting case out of Florida. We're talking about those three cases. Now, we just started the stream, so if you just now joined us, we are taking your questions live. They're getting fed to us right now. So if you have a question about these cases, self-defense, maybe a hypothetical question involving one of these cases, make sure to submit it in the chat because, early, beginning of the show, we'll have a good opportunity to get to it. But before, we go any further, make sure to hit that like button. Let us know what you think of the stream. If you enjoy these topics, make sure to leave a comment. But let's talk about these cases, Edwin. And I think we have to go over just some kind of general principles. And we gathered these from a previous discussion. When we're talking about self-defense cases in general, what are some kind of universal principles we see, with all state laws?
Well, we have, of course, the overarching principle is reasonableness. So with regard to pretty much everything somebody does in a self-defense situation, it's going to be judged under that umbrella of reasonableness. But then we can take that and then look at sort of subsets, whether or not the person who used self-defense, could their actions be characterized as being innocent, or do they bring clean hands to the situation? Also, one thing that a lot of people would need to consider is, was there an opportunity to, say, avoid the situation? Now, that may have limited legal impact, but certainly it's something that to be considered. Also, whenever they used force or deadly force in self-defense, was it proportional to the amount of force or deadly force that was used against them? And then, of course, before using force or deadly force in any situation, you want to make sure that you're responding to an imminent threat.
Yeah.
So was the threat that was being perpetrated against somebody, was it imminent enough to allow them to justifiably react with force or deadly force?
And I'd say that pops up from state law when we're looking at the black and white of what does self-defense law say, and we look at a survey of states, we see these themes pop up over and over again: imminence or immediate necessity, reasonableness, reasonable person standard, whether something would, put yourself in the actor's shoes, or how would an ordinary prudent person act, and then responding to, an unlawful threat, whether that's called force, maybe something that might hurt, or some states have some kind of intermediate level of force, or deadly force. Some people might call that deadly physical force. So they're called different things in different states, but what we see over and over again, this immediate necessity, it being reasonable, and then this response to something that's unlawful. And depending on how bad it is, that would justify how we act in response. And so when we look at the Kyle Rittenhouse case, and I think this one is a little bit tough because we really have, it's not just one self-defense case, we really have three self-defense cases smushed together. And so let's start with Kyle Rittenhouse and the first incidents when he was forced to use deadly force. Give us kind of a breakdown of what that looked like.
Well, so of course, there was a lot of media attention with regard to this case, and you can look at it to see that maybe this was perhaps a politically motivated prosecution, because
I think that's a big takeaway from this case.
Because objectively, whenever you look at this, if you were just to say, hey, if you're in a situation where you're lawfully in possession of a firearm and a man tries to take that firearm from you, can you then use that firearm in your own defense? I think objectively, most people would say yes. Similarly, with the second incident, if you were, trying to avoid a situation, if you're actually running away from a situation, and a man comes up from behind you and bludgeons you with a heavy wooden object, so much so that it could knock you to the ground and then try to strike you again, could you use self-defense? Most people would agree yes. Third incident, if somebody actually approaches you, runs up to you with a handgun, could you then use deadly force in self-defense? I think most people would say yes. So objectively, I think all three of those incidents are great examples of situations where I think universally people would agree you could act in self-defense. But because they happened in this particular context that Kyle Rittenhouse happened, that's what I believe motivated the prosecution, which just briefly, it involved the protest in Kenosha, Wisconsin. Kyle Rittenhouse there ostensibly was there to kind of aid in protecting people's property. A lot of people didn't like that. But if you just strip away the idea of what was his motivation, why was he there, those circumstances, and look at just the act of self-defense in a vacuum, I don't think anybody could disagree that he was unreasonable in what he did.
Yeah, and I would go into that first instance of Kyle being forced to defend himself, and this kind of ties in with George from YouTube. He asked if you come into contact with an escaped convict, can a licensed user shoot on site? There's never going to be a situation where it's going to be green light every single time, authorized use of deadly force, and so you have to look at each particular set of circumstances. And why I bring up George's question now is that first instance of self-defense in Kyle Rittenhouse's case, the person that he defended himself against just got released from a mental institution that day, threatened Kyle earlier in the day, saying, "I'm going to kill you." And then when Kyle is, out and about, I think what he said got his attention. He heard what he thought was a gunshot, turned, sees this guy that he had encountered earlier chasing after him. They wrestle over the gun and he shoots him fatally. But in that situation, if you just see, you're driving down the highway and you see a most wanted picture of a person, you memorize their face perfectly. You see that person out walking around. I don't see the law just saying, "Hey, green light, it's open season on that person."
Yeah, that is not a circumstance where the law would give somebody a presumption of reasonableness or really give somebody the means to even act.
Right.
I mean, an escaped convict who's, I guess for lack of a better word, just minding his own business.
Sure.
You can't just walk up to him and then try to use force or deadly force against them. Now, a lot of laws have laws on the books where civilians can assist law enforcement, things like that.
Right.
And you'd have to really dig into the details on something like that.
Yeah. And so I would say, George, go back to those principles that we talked about at the very, very beginning. Immediate necessity, reasonableness under the circumstances, and in response to, there has to be some kind of threat posed by this person. Their mere presence, maybe. I mean, we might know that they're a very dangerous person, and that might feed into our reasonableness if we're backed into one of those situations where we have to defend ourselves, but just without some kind of threat, probably not.
Yeah, and certainly if you recognize somebody as an escaped convict and they came up and were engaged in an activity that otherwise you would say maybe this guy's a threat, maybe he isn't, then I think that factor could weigh in.
Yeah.
For example, if they approached your vehicle.
Yep.
And he was like, "Hey man, just roll down your window. I want to ask you a question."
Right.
And that this is you have prior knowledge that this is an individual who's dangerous. He is just using this as a ruse,
right,
to get me to roll down my window so he then can carjack me. Something like that could go into, which is actually does kind of weave back to the initial Rittenhouse. The initial person that he had to use deadly force against was that this guy had previously demonstrated how dangerous he was.
Right.
And then when Rittenhouse tried to avoid the situation and say, "Look, I don't want to, I'm not confronting this guy. I'm actively trying to avoid this guy." And the guy actually chases him down for the sole purpose of trying to wrestle his rifle away from him. That's got justification written all over it.
Yeah, and I would say of the three self-defense incidents, that may have been, I would say, of the three, the most ambiguous, for lack of a better term, because I don't think that one was captured on video as clearly as maybe the following two. So moving on to the second one, that incident happens. He starts running away. He's chased down by a guy on a skateboard, pushes him to the ground, picks up the skateboard, gonna hit him with the hard metal trucks of his skateboard. Definitely a deadly weapon, definitely capable of causing serious bodily injury or death. And we have that imminence right there. I mean, the skateboard is coming down. Would you say that, and clearly he was found not guilty, but we see those elements of this being justified under those circumstances. We see all of those elements, Matt.
Yes, and in all three of those Kyle Rittenhouse circumstances, you had the presence of a weapon,
Mm-hmm.
a deadly weapon. In the first incident, even though the guy didn't have a gun, he was fighting over Rittenhouse's gun.
Yep.
So anytime you're fighting over a gun, you can, the situation is now that it's a gun.
Yeah.
It no longer is Rittenhouse's gun. It's a gun because clearly the guy's intent was that if he got a hold of the gun, he was going to use it against Rittenhouse and maybe others.
Right.
So the fact that there were deadly weapons present in the Rittenhouse case, I think also really swings in Rittenhouse's favor. That he could articulate, I had a reason. My fear of death or serious bodily injury was reasonable because he was fighting me for my gun, or he tried to bash my head in with a skateboard, or he actually had a pistol that was pointed at me at the time I shot him.
Yeah, good point, because then we go to that third incident where, he's on the ground, person runs up to him, I believe it's Alan Grosskreutz, if I'm saying his name correctly. At that point, he runs up to him. Kyle demonstrates that he has the ability to defend himself by pointing his rifle at him. What we see was very interesting in this interaction because he seems to say, hey, I'm not a threat by lowering his hands, and Kyle responds in kind by lowering his rifle. But then immediately following that, the guy pulls a handgun, obviously a demonstration of the ability and imminence of a use of deadly force. And I would say, again, Kyle responds proportionately imminent, and that's how most people, if you find yourself in that situation, I think that's how a reasonable person is going to react.
Yeah, and I think the guy admitted as much on the stand.
Yeah,
So.
no, and from his perspective, he was stopping a person who was shooting. But, that's where we go back to right at the beginning. We talked about that unlawful element that we have to see. And so was, Kyle acting unlawfully up until that point? No. And we saw the jury say not guilty on all three charges. Let's go on to the McMichaels case. This took place in Georgia. Kind of brief if people aren't familiar with this case. It's worth looking up. But we have the McMichaels. They're at their house. They've been notified by a neighbor that there's someone, rummaging around on their property. Their property had previously been burglarized several times.
Well, the neighbors.
The neighbor, yes. And so they think, in their minds, I think they think maybe a burglary is going on. So they go out looking for this person because the police response in their neighborhood is kind of lackluster. They kind of live remotely. So they go out and they encounter Ahmaud Arbery at this point running on a roadway. And what kind of happens from there?
Well, the McMichaels, they were aware of this house. So it wasn't the McMichaels' property that was being supposedly burglarized or being, that Ahmaud Arbery was supposedly prowling in, which I think there's surveillance video that shows that he was. But then they basically said, we have a belief that this person had engaged in a crime, and now this is the part that's really difficult to understand. For some reason, we're going to chase after him, even though he poses no direct threat to us, and in fact did not even take any of our stuff. Even if you do believe, even if he's running down the street with a power saw or whatever that he could have taken from this construction site, it's not the McMichaels power saw.
Right.
And so what interest did the McMichaels really have in doing this? Because one thing that, regardless of what state you're in, the defense of property laws, even in the state of Texas here, are very complicated. There are many states that do not allow you to do anything with regard to defense of property, unless it's your property.
Right.
And certainly there are even fewer states that allow the use of deadly force. Now, during the trial, their theory of their defense kind of changed to where it moved from sort of a strictly self-defense case to we were trying to effectuate a citizen's arrest type of thing,
right?
Which is even more fraught with peril,
right?
Because if the citizen's arrest laws are not clear in any state, and that's where you really run the risk of being considered to be a quote unquote vigilante,
right? And what we see with citizen's arrest, it's usually observing some kind of felony. You have to observe the felony, and at that point you're intervening. It's going to depend on your state, obviously, but we see kind of those themes pop up from time to time. But unlike a defensive third person, where in many states say you basically place yourself in the shoes of the person who you perceive as being attacked, to what extent would that person be justified in using force or deadly force to defend their own lives? Well, then you could theoretically come to their aid in that same capacity. That's what we see with defensive third person. We don't see the same thing with defensive property.
No, and in fact, in this case, it's really kind of even worse because I don't think objectively there was any evidence that Ahmaud Arbery had taken anything. They didn't observe him with anything running away. Nobody had reported specifically. It wasn't like and one key element that's present in most states' citizens arrest laws is that they contemplate that an individual is acting in response to a request for assistance from a police officer. It's usually done at the direction of a police officer. So, so obviously none of that was present here.
No.
And they chased the guy down, and then they had their own weapons. He was unarmed. So, it really would have been kind of interesting if, let's say that Ahmaud Arbery had have shot one of the McMichaels.
Let's say because I think we're kind of dancing around it. But what eventually happens? The McMichaels stop. They pass him, stop. He's running past them. In the process, he attempts to wrestle their firearm away from them. They don't lose control of the firearm, and they end up shooting him dead. But I think that's an interesting, theoretical hypothetical. What if he had taken the firearm from them and shot? At that point, maybe he's charged, and he's, at his self-defense is being questioned at that point.
Yeah, but I think looking at it, I think he actually, if that situation had occurred, his situation would have been much more like Kyle Rittenhouse's situation. Yeah. Is that I think he would have had a really applicable self-defense claim.
And I think that's most of us think, what would I do if I was in that situation? If you wrestled a firearm away from a perceived attacker and shot them in defense, I think a lot of us think, hey, that should be justified. But I would say kind of our big takeaway, if we have any takeaways from this case, really undercuts your immediacy when you're the person going out, essentially looking for trouble, or putting yourself in a situation that you may not otherwise be in. And as far as proportionality or the amount of force threatened, you have 3 guys armed versus 1 person unarmed. I think it undercuts the proportionality argument there as well. And it goes to, I'd say, another thing that we see pop up in state law from time to time is, provocation, whether it's a legal provocation. A lot of people think provoking, they think starting. Legally, maybe it means something a little bit more specific. Do you want to talk about that just very briefly?
Most states contain in their self-defense statutes the issue of provocation, is that people cannot provoke a situation basically and use that as a pretext to then use deadly force in response.
Yeah.
And I think they tried to make that an issue in the Kyle Rittenhouse case by saying all of this political stuff about why he was there and he shouldn't have been there. But provocation, I think, clearly is the important issue in the McMichaels Ahmaud Arbery case, where they could have done literally anything other than chase the guy down.
Yeah.
With guns and pickup trucks. So I think it's really easy for the prosecutor to demonstrate that they intended some sort of deadly force to be used in their action, and that would constitute legal provocation that would basically eliminate the justification of their self-defense claim.
Yeah, and I would say if we have one more takeaway from the Ahmaud Arbery case is video evidence. A lot of people say, I'm going to put a dash cam on, or I'm going to record the incident with my phone, or I think a lot of us think, well, I'm a reasonable person. I'm going to act reasonably no matter what situation, whatever the world throws at me, I'm going to act reasonably. And I think this is a good demonstration that video cameras go both ways. They capture the good and the bad. In this case, they captured, bad, and to the McMichaels' detriment. So just inherently video recording something, not necessarily always the best.
Oh yeah, no, because and that's the way most lawyers portray it, and that's the way most jurors accept it, is that the video is the video, and that's going to be, other than being an eyewitness, which if you're an eyewitness, you can't be a juror.
Right.
But the video, having a video, some sort of video, is the closest that you will get to actually being an eyewitness to a situation.
And I would say, and just another, and I don't necessarily like this phrase, but I can't think of a better one, is that video cameras lie sometimes. And that comes with the idea of, distances, times, where a person's focal point may be. Maybe I'm holding out my cell phone camera, I'm recording like this, it's capturing what's in front of me, but my head is turned to another direction. It doesn't accurately reflect what a person is perceiving at the time whenever, they find themselves in these situations. I think a lot of jurors may hold that against people.
Yeah, there can be a lot of issues with regard to a video perspective, what it didn't capture. Perhaps there was, it may show that somebody shot somebody and the person is unarmed, but what it doesn't show is that there's actually an individual standing behind that person, pointing a gun or doing something other aggressive. So video does have its limitations, but I think at the end of the day, most jurors think that really is the best kind of evidence, and you can't always, even though it may be your video, you can't always count on it being interpreted as being in your favor.
Yeah. All right. Well, let's go on to the Curtis Reeves, Florida popcorn movie shooter case. Now, I think this one flew under the radar a little bit because it occurred all the way back in 2014, and just due to the procedural mechanisms in Florida, this thing drug out for a very, very long time. And so,
and the COVID.
Yeah, and the coronavirus slowed things down, mucked all the courts up. And so finally this case went to trial. And if you didn't hear about it, we have retired police captain Curtis Reeves. He's 71 years old. He goes to see a matinee with his wife. There's another couple in front of him. One of the person below them is texting. The trailers are playing. He's upset, that the guy is texting on his phone. I mean, we've seen that person ruin a movie experience. And in response, he gets up to go talk to movie management and say, hey, this guy is disrupting the movie. He comes back, and kind of an argument ensues. And where does it go from there?
Well, they continue to bicker with each other. And I think the words get a little heated. And keep in mind, this really isn't just an unfortunate confluence of circumstances, because they were there to see a matinee movie in the day. The theater wasn't packed. If either one of these parties had just not sat directly in front of one another,
right,
this possibly could have been avoided. But then they get into an argument. Finally, the individual who got shot stood up, turned around. Is a very tall individual, 6'4", and throws his popcorn at Mr. Reeves, who's sitting down. So you got kind of this big guy looming over him, throws popcorn at him, and as soon as the popcorn is thrown, Mr. Reeves, who carries a handgun in his pocket, pulls it out, shoots the guy one time, and actually shoots the guy's wife in the hand because she's trying to, she knows that there's an altercation brewing, and so she actually is trying to restrain her husband and gets shot in the hand in doing it. And this case is actually the most interesting of the three, because I think reasonable people can agree that Rittenhouse was acted in self-defense.
Yeah.
And I think all reasonable people can agree that the McNichols were clearly out of line and did not act in self-defense. This case, I think, runs right down the middle. I think you can get reasonable people on both sides to say Mr. Reeves did not act proportionally, that he kind of, was kind of egging it on with his continued bickering about this.
Yeah, maybe.
That, the movie hadn't started yet, so it wasn't like the guy was, in the middle of the movie texting. He had just simply texted before the movie started. So there, a lot of the things we talk about, there's reasonable differences of opinion on all of those.
Yeah, and going into, a person's mindset or reasonable belief at the time they act in self-defense, we get a great question from Tony on YouTube. I'm on blood thinners. Doctors have told me I should be careful about receiving blows to the head or other parts of my body. Does that change the criteria for deadly force? And I think that's an incredible question, because we have our reasonable person standard, and states it's going to depend on what your state looks like. But what we see come up over time and time again is, a subjective belief, what's held in the mind of the actor or self-defender at the time they act in self-defense. And so,
correct. The self-defense is a very unique standard in that it purports to be an objective standard. The reasonable person is what lawyers learn in law school is what we call an objective standard. But all of the circumstances that go into the person's belief are all subjective.
Yeah.
And because most laws are very clear that you look at the circumstances from the point of view, and this has to do with reasonable doubt, from the point of view of the person who is accused.
Yeah.
You have to look at it from the defendant's point of view. So yes, if the defendant gets on the stand and says, look, I am very susceptible to being injured, I am on blood thinners, then that's the reasonable person. It's the reasonable person who is on blood thinners, who is more fragile, who is older, who may have some sort of physical disability. And so those factors are considered as to whether or not that individual, an individual in that circumstance, would have behaved in the same manner as an ordinary prudent person in that same circumstance.
And we see that come up, I'd say also, mobility issues. I see that come up with a lot of folks who have mobility issues. And that kind of plays into, kind of a stand your ground. I think it's worth discussing in this case. And when we talk about stand your ground, we're talking about that there isn't a legal duty imposed for the actor, the self-defender in this case, to flee before they are acting in self-defense. And so in this case, Mr. Reeves not committing a crime at the time that he, acted in self-defense. I don't think that there would be legal provocation in this case. He wasn't trying to generate a pretext for this person to attack him so that he would respond with deadly force. Because he's not meeting those criteria, not committing a crime, I'm assuming also not committing a crime, legally allowed to be where he is, not provoking, that he would not have a duty imposed on him, that he would have to run away.
Right. And this is where it's very important that an individual read their state laws or become familiar with their state laws, because not all states have a stand your ground or a no duty to retreat provision. Many states do, but heck, even Texas didn't have one until 2007. They had one, but it only applied to your residents. So all the issues that we've discussed today about why you were there, why you did what you did, was there an alternative that you could have taken? If you're in a state that allows all of those to be considered, then you're going to have prosecutors argue, look, using deadly force is your absolute last resort. You have to explore, you have to give that jury a reason as to why you didn't do any number of alternatives, such as call the police or run away, or if you're in your car and somebody's trying to carjack you, drive away.
Yeah, because we see a handful of states where there is not only is there not a stand around, I mean, there's a legal duty imposed on you to retreat. In most of those states we see it doesn't exist inside of the household. But when you're outside of your house in these, what we'll call the usual suspects, the law is saying, hey, a jury is allowed to second guess that when at the time that you acted in self-defense, was there some reasonable, safe alternative to you actually pulling the trigger in that case? I think it's out of New Jersey, that famous Dunkin' Donuts case where employee robbed, but because he defended himself and it spilled over outside of the workplace, a jury was allowed to consider, his failure to retreat in that case, which is just absolutely insane.
And that can be really dangerous because that, of course, if you have a very clever prosecutor, they may come up with some reason out of left field.
Well, they have years. They have
anticipate.
Years to come up with all the different ideas that you could have taken. So I mean, whereas we're not given that same benefit as the self-defender. I mean, we're acting in split seconds, and so the second guessing there is, I think, a little suspect. We got a question from BSafeCCW from YouTube. Do some states actually allow responding to deadly force to protect property, like vehicle break-ins? And I'd say, going back, we kind of discussed this earlier. The answer is yes, very rarely. But I will just tell you, as a general rule, juries value lives over stuff, and so when the only thing threatened is, an unoccupied vehicle, I think juries have a hard time. Let's say the law, assuming the law allowed it, I see juries having a hard time wrangling with that if there's no danger to a person, wouldn't you say?
Oh, yeah, absolutely. And there are very, very few states that come out and say you can use deadly force for something that is strictly a property crime. And you see this even in the states that have created what we commonly refer to as the Castle Doctrine, which is generally described as a legal presumption that you're reasonable in using deadly force when in certain circumstances. Most notably, those circumstances would be inside of your occupied habitation, inside of your occupied motor vehicle. And so that's kind of the distinction that they draw. They don't say you get a you get a legal presumption for defending a habitation.
Right.
It's an occupied habitation. It's an occupied vehicle. And so that kind of shows us that that state has considered property that doesn't implicate a personal risk different than property that does implicate a personal risk.
And then one more question, and kind of to button up the Curtis Reeves case. So Stan from YouTube saying, being 78 years old, do I have more leeway with self-defense than, say, a 30-year-old? I think that's exactly what we saw in the Curtis Reeves case. 71-year-old captain, early 40s, 6'4", kind of muscle-bound perpetrator in that case. And I think it's something that juries inherently analyze when they're looking at proportionality, opportunity, ability to use violence against another person. And so, and even some states might say, hey, you could use force, or you could use deadly force in response to a felony or forcible felony. And we see a lot of states say people over the age of 65, maybe you're considered, sorry to be the bearer of bad news, maybe you're considered an elderly person.
You're an at-risk group. But yeah, that's exactly the sort of thing whenever a lot of people use the term disparate force.
Yeah.
And so, yes, a 20-year-old beating up a 65-year-old, that absolutely will come into consideration when the jury thinks about that. And I think that one of the things that is not really talked about in the Curtis Reeves case, but that is really important, is that because I believe reasonable people can disagree, was he justified, was he not, that the one thing that we rarely talk about is the legal standard of beyond a reasonable doubt.
Yeah.
And I think
that's what this case came down to.
Yeah, the jury really took that to heart to say, look, we may disagree as to whether or not we would have used deadly force in that situation, but can we really convict somebody and send them to prison by saying that there is no possible reasonable way that this man would have not believed that he was justified? And so it really is a credit to that jury understanding that legal standard, understanding how powerful it is, and understanding what it's, how it's used in the criminal context, because I think so many juries really kind of disregard what beyond a reasonable doubt means.
And I'd say if there was if there was another takeaway, it would be that case lasted for 8 years. Can you imagine having a murder charge hanging over your life for 8 years? How life disrupting that could be. And maybe Curtis was retired, but if you're a regular person still trying to work a regular job, still trying to raise your family, pay your mortgage, that will destroy your life, having a murder charge hanging over you for 8 years. And the expenses involved with having to defend that over that period of time, because it's not just, hiring an attorney, maybe having to pay a judgment at the end of the day. Maybe it's not just getting sued, but losing your job, that's expensive as well. And so, having your resources lined up in case you find yourself in that situation, I think is also really important. But I think that brings us, we're out of time, but we hope you enjoyed this discussion. Please continue to leave your comments. Make sure to hit that like button, but leave your comments. This is where we source future discussions. And so if you have a question that we didn't get to, make sure to post it again. We have the live chat. There's a chat below the video. If you're watching this on the replay, make sure to leave us a comment, because we want to keep these discussions going. We hope you enjoyed this discussion. Edwin, thank you for joining us.
Oh, it's my pleasure.
And we'll see y'all next time.